Swayam Prabha. Digital India. Educated India.
Dear students, we will continue with the next category of intellectual property rights, that is the copyright. As you know, this is one of the important intellectual property right in writings, books, and also a series of rights bundled in copyrights. And copyright is one of the important intellectual property law in the recent times, in the sense that now everything is digitalized. So, in a digital era, copyright is very important as far as all the informations and databases are concerned. So, earlier it will be considered as the author's rights or performer's rights, and you can see this is the book which I recently published on intellectual property rights and competition law. The copyright is with me, but in most of the cases the copyright owner may be somebody else. The publisher can be the copyright owner. So, in the case I am the author, is the copyright owner as well. So, what are the differences between these author's rights, the performer's rights, the person who is writing a song, a person who is singing a song, the person who is giving music? All these are very important to look into, because mostly the violations are happening in the copyright. So, we will see one by one. So, you can see the pictures are on the left side is a poet and right side is a college lecturer, and recently there was a controversy that the professor has copied the poem of the author, and then later on and she said that yes, I copied. So, and some time back the Delhi University vice chancellor was jailed for violation of copyright. So, the allegation was that he copied some of the parts of his students' thesis. So, what I want to say, it is copyright is not the right to copy. So, copyright may end up in jail, and copyright is the another intellectual property law where the imprisonment is prescribed. So, it is very important to look into these copyrights, and copyright can be it is not a right to copy. So, it is a bundle of rights, and you can see that it is in different formats. It can be the works can be in recorded format, it can be in a written format, and you need not even register the copyright. Once you are written it down and the copyright is with you, and it means that the copyright is automatic when you created a piece of poem, or once you write down a book, once you write down an article. And here again, so you can see that it gives, the copyright gives automatic protection to specifically the authors and the original expression of ideas, and also the information which is captured in different medium. The medium can be even digital medium, like whether it is pen drive or it is any computer disk or even in any other format. So, again the copyrights mostly you can it is copyright is protected of books, films, music, any sound recordings, newspapers, magazine, artwork, etc., etc. That means the once you put the idea into the paper, and it can be protected as a copyright, and also it is also protects the originality created, that is typographical arrangements, databases, media broadcast, computer programs, and even compositions of other people's work such as academic journals or CDs and compilations. So, the copyright protects a different kind of intellectual property works or different kind of the literary and artistic works are covered by the copyright. As I told you, this it covers literary and artistic works. So, in different formats, it can be in the format of photograph, it can be in the format of books, it can be any other literature, illustrations, maps, or even plans and sketches can be copyrighted. That means that an automatic right is created once you complete the work. And what are the things can be copyrighted? And basically all literary works can be copyrighted if it is original, and musical works including any accompanying words. So, musical works includes it can be poems, it can be the songs of cinemas, the songs for the film industry, or in any other format, the musical works can be included. Then it is the dramatic works, dramas, and also the dramatic works plus music, which includes can also be protected. Then the pantomimes and the pictorial, graphic and cultural works or sculptural works, which can also be protected under the copyright. Then motion pictures and all other audio visual works can be copyrighted. Even architectural works also can be copyrighted. So, copyright protects a wide variety of works in its works which can be included for copyright. Then what are the rights covered? It is not only the rights covered, the original rights, it is the moral rights also covered. So, you can see that it is the author's rights or the paternity of the author is inalienable, non-alienable. What does it mean? It means that you can assign the copyright to the publisher, but you will be continue to be the author of that particular work. The owner may be the publisher, but you continue to be the author of that particular book. Then economic rights. So, always the economic rights are with the owner of the copyright. It is the right to exploit the work, the economic exploitation. So, the rights of translation and rights of performance, for in the case of dramas, the rights of performance, and then right of reproduction, etc. All these are with the economic rights, all this will come under the category of economic rights. So, these rights can be transferred like any other property, it can be assigned, it can be licensed for absolutely for economic benefits. Because we know that the music industry, if you take the film industry or the music industry, is surviving because mainly because of there is a stronger protection of copyright in these industries. And who is the author? And it is a very pertinent question with regard to the copyright is concerned. Usually, as I told you, as far as book is concerned, the writer or writers of the book are the authors. The painter, if you take the question of a picture, it is the painter is the author, and it is the music composer is the author, it is the translator is the author, and cinematographer is the author, and photographer is the author as far as the copyright law is concerned. And what is the duration of the protection? And the duration of the protection is prescribed in the TRIPS agreement is the life of the author plus 50 years, but the Indian law which gives a longer protection, that is the life of the author plus 60 years. That means these rights can be even transferable or to the successors. So, as I told you, it is basically in some of the countries it is 50 years to 70 years. So, the TRIPS agreement prescribes only the minimum period of 50 years. And for photographic works, it is 25 years from making the works. So, you can see there is a difference in the case of books and other works of arts and photographs. And for cinematographic works also, it is 50 years after making the works available to the public. That is the duration of protection. So, when compared to other intellectual property like patents, it is 20 years, trademarks it is 10 years, geographical indications it is 10 years, which can be renewed successfully from years to years. Here the duration of protection is much longer than when compared to other intellectual property rights. And if you want to use any work, you require the permission of the copyright owner. It is mandatorily required is to make copies. So, it is in this background, it is very pertinent to is mention one of the Indian case, that is the Rameshwari photocopy services versus the other publishers like Oxford, Cambridge and all other publishers. In this particular case, these well known multinational publishers sued a small photocopy center in the Delhi University premises, which makes study materials, and these study materials are prescribed by the teachers of the Delhi University from time to time, and these materials are taken from different books and other journals, and the photocopy sender which photocopy these materials and compile it together and sell it to the students for a minimum price. So, these publishers argued that it is the violation of their copyright, but ultimately the Delhi High Court said that the extent of copying for the purposes of educational purposes is not the violation of copyright. So, in India, to what extent you can copy from a particular work, copyrighted work, is not mentioned in the act, or there is any policies of the government which shows. In other countries, each and every education institution have a policy of how much you can copy, whether it is 10 words or 10 pages, or it is 10% of the work or 5% of the work. But India still it is in the developing stage, and it is there is no hard and fast rule for how much you can copy. But the one thing is very clear under the act, you require a permission from the copyright owner for copying the works, where it is copying in the sense that copying in any format, whether it is a digital format or in this hard format, or copies to the public, whether it is free or not. So, the question is whether you are charging or not, it is not important, but the question is whether you are copying it or not. And then also you also require the permission of the copyright owner in order to translate the work to another language. That is also is a part and parcel of the copyright. So, the permission can generally be implicit and it must be explicit. The implicit permission is not is considered, it must be an explicit permission in the particular agreement for transfer of copyright is required from the owner of the copyright. And exceptions, the only exception which is mentioned in the copyright acts or copyright laws are the fair deal. Or what do you mean by fair deal? I just mentioned about the Parameshwari photocopy case in the Delhi University. So, the fair deal is discussed by the Delhi High Court in length, and they said that for educational purposes is a fair deal, and to the question of what extent you are copied is not the question, but for what purpose it is copied is the answer, the question to be answered. For example, if you are quoting for commentary, so if you are writing a commentary for a particular copyrighted work, again it can be copyrighted, and also illustration for teaching, this is also exempted, and also the news reportings, are also exempted from these copyrighted works. So, it means that the quotation, if you are quoting from a particular book or somebody's work, so you can acknowledge that particular work, it is an exception to the protection, exception to the copyright or its rights which is embedded in that particular work, whether it is a book or an article. And something ownership rights are something different from authorship rights. As I told you in the beginning itself, the ownership rights and the copyrights general goes to the author, but the author can assign to the owner, which may be another person. So, the product, as I told you, the product the copyrighted works can be given to another person. If an employee works in a company, the employee may assign it to the employer, that is, or to the company, and it depends upon what kind of agreement between the employer and employee exists. So, it means that if somebody is working upon something, the copyright, the ownership of the copyright will be depend upon what type of contract between the employer and the employee on the intellectual property produced by the employee. So, the employer may own the copyright of the work, but still the employee is the author. And but in the case of freelance works or the independent contractor, the ownership differs. And in the usual course of contracts, usually it is with the person who hire the contract, that means who is hiring the work for money, who is supposed to engage, who is engaging the work will be the owner of the copyright. The case of independent contractor, which I talked about, is usually the copyright owner. The independent contractor is the copyright owner. So, and but there is all this will depend upon the agreement between the parties, who owns who others. And always when you publish with the publishers, there is a publishing agreement which clearly talks about who owns the copyright. Another category of subcategory of copyright is the related rights. As I mentioned to you in the beginning, that a person, a composer of song composes the song and he directs the song, but somebody else is singing the song. For example, most of the songs in films, the singers are different. So, what is their rights? They also have some kind of rights, which are a bundle of rights which are known as the related rights. And related rights or known as the neighboring rights. Neighboring rights are always rights related with the copyrights. These protect the performers, those who do the work, performers of work, and the producers of phonograms and the broadcasting organizations. So, it means that the related work or neighboring rights are related to these copyrights. I mean, they also have some kind of rights. Once it comes to the software patents, because it is very important to discuss the copyright in the digital era. And India never provides software patents, and software per se is not patentable in India, and the software must be attached with hardware, then only it is patentable in India. So, software can get only a copyright in India. In most of the jurisdictions, it is not software patents, it is a software copyright in softwares. So, softwares in India cannot be patentable, but the US position is that they give the software patents. So, in the digital era, the patenting to softwares or patents to software is very important in the sense. So, there are two side arguments, and some scholars argue that it is not required, software cannot be patentable and only copyright is required, and another group of scholars argue that you must provide the patent to software, because it will come under the purview of very strict implementation of the patent implementation. So, the softwares can be protected, which will change from very quickly change from time to time with the change of technologies. So, you can find this is one of the market in one of the the markets, and India and China is in the radar of the US, and very recently the US have released their 301 list. The 301 list, watch list, is nothing but is the US will prepare every year the countries, those who are not implementing the intellectual property rights honestly or completely in their at the domestic level. So, the US, we are in the list, India is in the list of 301 list of the US from the very beginning of WTO from 1995 onwards, and in 2019 also they put us under the 301 watch list for not implementing or honestly implementing the intellectual property obligations at the domestic level. So, if you go to some of the markets, you can get the pirated, the so called pirated in inverted commas, the pirated CDs, and in the markets. So, it is the duty of the implementing authorities or enforcement officers to implement the intellectual copyright in total. So, copyright has to be implemented under the WTO TRIPS obligations. And remedies, as I told you in the beginning, that copyright is one of the law where there is the punishments, both type of damages as well as the jail time is prescribed. So, it is the civil remedies, criminal remedies and administrative remedies are available for the infringement of copyright. And civil remedies include injunction, damages and accounts and also for cost. So, this can be claimed by the copyright owner from the infringer. And the criminal remedies, as I already mentioned that even a vice chancellor can be sent to jail for a period of 3 years. So, it is a cognizable offence, and any person who is infringing copyright can be sent to jail, and also there is a fine up to 2 lakh rupees. So, it is a serious offence. In India also it is considered as a serious offence of copyright violation. So, we have to be very careful about when we are taking materials from others, whether it is from books or whether we are dealing with CDs or whether we are dealing with even teaching materials. We have to be careful when we are taking the materials from other sources. So, as I already mentioned, the offence of the infringement of copyright is put in the. So, it is a very stringent punishment, but the question is how many people are punished under the Copyright Act or sent to jail under these particular provisions. But it is very clear that under the TRIPS obligations, the copyright provisions, it is the duty of the Government of India to implement the provisions at the domestic level in its total. As it is a WTO obligations, otherwise other members can take India to the WTO dispute settlement body for non-implementation as accused by the United States. But India always claims that India honestly implements the TRIPS obligations at the domestic level and passed appropriate legislations from time to time, and the enforcement authorities enforces and they conduct raids at different places every year for implementing these intellectual property rights. So, I already told you that the copyright is one of the important intellectual property law, and which will affect not only it is affects the ordinary people, affects intellectuals, affects students, affects teachers. So, everybody has to understand the copyright, as it is not the right to copy, you require the permission from the copyright owner for copying anything. And so we will wind up and we will go to the next category in the next class. Thank you.